Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today we'll be exploring how the burden of proof requirements in New York differ between an evidentiary hearing and summary judgment. I'm Adam Friedman, managing partner at Friedman Bartolo, and helping us work through this complex topic is a fixture of the New York default industry, Friedman Bartolo Senior Trial Counsel Henry DiStefano. How's it going, Henry?
I'm good. Thank you, Adam. Thank you for having me.
You got it. So Henry's the leading authority on New York foreclosure litigation and trial procedures. He joined the firm years ago with a wealth of experience and a proving track record. Very excited to have him, and I'm sure he'll do a fantastic job. Before we fully jump in, Henry, can you explain these two terms to me, right? So burden of proof and standard of proof, they sound similar, right? Like, what's the difference? Why are they each important?
Okay. So with respect to the burden of proof, what we're discussing is who has the burden to prove their particular case or point.
Okay, and we mean, though, a plaintiff is proving the defendant is guilty or wrong or whatever it is. And the defendant, if the burden's on them, it's to prove their innocence.
Prove their innocence, or at least demonstrate that the plaintiff has not established or presented enough evidence to establish the defendant's guilt.
Okay. And then what's standard of proof?
So standard of proof is the legal standard that's being applied by that judge in considering whether or not the party with the burden has actually proven its case.
All right. So burden of proof, right? It sounds like there's two possibilities of who has the burden, right? Standard of proof, is it, I know it's not going to be two, but is it something similar where it's like almost like an easy answer, like three different types of standards, or does it vary? Like, is it moving? Like, how does that work?
There are different standards to the extent that it moves. It's more so a matter of the type of case as opposed to something changing in the middle of a case where the burden could actually change in the middle of a case.
So when you say type of case, what type of a case would have a more strict or a more difficult standard of proof? Strictest
standard of proof is going to be in a criminal action. The primary reason being that the ultimate consequence for the defendant could be going to jail.
Okay, so the worse the consequence, the higher the standard.
Exactly.
That makes logical sense.
Absolutely.
Okay. What's required for a summary judgment motion? What's the standard of proof?
So on a summary judgment motion in a civil case, you're looking to meet a standard where you're demonstrating there is no genuine issue of material fact. And in the absence of material fact, the plaintiff is entitled to a judgment as a matter of law. Lower than the criminal standard of beyond a reasonable doubt, but significantly higher than an evidentiary or a trial standard.
Okay, so you're saying there's a lower standard of proof for a trial.
That's correct.
Is that right? So can you walk us through that? Like, what does that mean? What's required?
So to equate the two, in a summary judgment motion, plaintiff needs to present its proof, which generally has to approach a high likelihood of truth. It's the best way to articulate it compared to the other standards. But it is slightly different than saying no genuine issue of material fact. A judge on a summary judgment motion does not have to make a determination other than whether or not there actually is an issue. And that is significant because he's not saying the plaintiff is correct. He's not saying the defendant is correct. He's just saying, I identify an issue that precludes me from rendering a decision on a motion. I'm going to give the defendant their day in court on a trial on the merits.
Okay, so in essence, there's an issue. We're going to give them a shot at a trial to flesh this issue out and see if they're right.
Absolutely.
Or not guilty. Okay, that makes sense. Let's bring this back to our industry and our core practice, right? So what does this mean for us? So when we're representing a plaintiff in a foreclosure action, what's the standard of proof in a summary judgment motion, and then what's the standard in a trial?
So in a foreclosure action, in order to prove your case, you have to establish a prima facie case. The existence of a note, existence of a mortgage, proof of default. That's required no matter what type of foreclosure action you have, whether you're in a summary judgment or an uncontested case. Where it gets more involved, obviously, in a summary judgment case, is the defendant serves an answer and has affirmative defenses. The affirmative defenses have to be addressed, the most popular being standing, lack of compliance with prerequisite notices, whether or not a notice is properly prepared, whether or not it was actually mailed. Those are essentially the standard defenses that you're going to see in virtually every single case.
Why not just go to trial? Like, why even file a summary judgment motion if a trial has a lower standard?
It's a good point, and there's actually some in the industry that think that it makes more sense to go to trial rather than to go to a summary judgment motion. I don't necessarily agree. Although the standard in a trial is considered lower because it's the preponderance of the evidence, meaning I'm demonstrating that it is more likely than not that my evidence and my claims are true, you still have to present your evidence. You still need to present a witness. Filing a motion for summary judgment, you are presenting your evidence, and in some ways you're actually drawing a response from the defendant, which might be material to what might happen at a trial. There's a mechanism to address that, but
I imagine also there's a time component.
Time component is absolutely a consideration. A summary judgment motion is filed. Once the motion is submitted, the court is expected to issue a decision generally within 60 days of submission.
Okay.
That's the general time frame set by the court.
And let's say we were not filing that motion, or the motion was denied, and now you're proceeding to trial. How long roughly is it to get a trial date?
It's going to vary from jurisdiction to jurisdiction.
What's a bad one?
A bad jurisdiction.
A long time frame.
Don't hold this against me, Kings County, but Kings County. I, at this very moment, have a case that was released for a trial judge assignment 17 months ago, and I'm still waiting for a judge.
Okay.
Circumstances may have affected that, but regardless, it's 17 months later.
So really, if you want to give an easy answer to the MSJ versus trial question, you could probably just say time, right? Like
Time.
It's a lower standard, but you could be waiting a significantly longer period of time.
Agreed. The other thing that's also beneficial with the summary judgment motion is what you're hoping for is if the court decides that it's going to deny the summary judgment motion, it might grant portions of it. So it'll limit the issues that will go forward in a trial.
Okay, so let's just say I'm a client of ours, I'm a plaintiff, right? I've now learned a lot about burden of proof, standard of proof, very educational. Can we make this can we turn this into a practical conversation? Like, what does this mean? Like, what should I be aware of? Is there anything, like, what should I be doing to prep my attorney or interviewing my loan file? Like, what should this do to my job or day to day?
Most important thing about any case, even if it's not foreclosure, is you have to have evidence. You have to have admissible evidence. It should be detailed. Presumably with a loan, it's probably voluminous, and it needs to be maintained and verified. In our industry, loans get sold and servicers transfer on a fairly frequent basis. Documents on a loan originate from the time of origination going forward. Each servicer and each owner should be maintaining those records and passing them along to the successor who should verify those records, because at the end of the day, if you're filing a foreclosure action and you're filing a motion or going to trial, those records are going to carry the day, not just testimony, because a testimony without evidence is conclusory and is not going to win you a trial.
Thanks. Look, that was a very good explanation. This is clearly a pretty complicated topic, and I think it's something that the listeners can really benefit from hearing, because these terms get thrown around, right? And I think having them broken down the way you just broke them down was really helpful, and I appreciate it. Again, Henry's an absolute fixture in the New York industry. I've been trying to get him on here for a long time. He's a very busy guy, in and out of courts all the time, so I really do appreciate you hopping on.
You're welcome.
So thanks for joining Henry DiStefano and I on the Weekly Friedman, your source for the most essential information in the default industry. As always, if you have any questions or comments, please leave them below. And looking forward to seeing you next time, and thanks for tuning in.